Got the recording going. All right, good afternoon, everyone. Welcome. My name is Mary Lou Alvarez. I am so happy to have you. And of course, the 45th District Court is incredibly honored and excited to host our fourth Lunch and Learn presentation, Building Domestic Violence Awareness, here in our community. Thank you so much for being present. Thank you for spending your lunch hour with us. I think you will find that today's presentation is going to be an exciting one. We are blessed to have advocates with us who are incredibly recognized for their time, their talent, by their peers, as well as by the bench. Anybody who has them on either side of the protective order litigation will realize very quickly how lucky they are to have their skill set and how lucky we all are to have them share their skills and their with us today. So without further ado, because we do have four speakers who are going to be sharing with us, we're going to get started with Judge Guerrero and Mr. Richard Losa. They're going to be speaking with us for 20 minutes, their trial tips and strategies and all things from the perspective of representing applicants. Then we will move on to the presentation with Mr. Ernest Acevedo speaking with us for about 10 minutes on his for representing folks from the perspective of respondents. And then Mr. Marco Bass will be speaking with us on the same for another 10 minutes. And that should leave us at least 10, if not 15 minutes to have a lively conversation and answer all the questions that you may have. So the chat is open. If you would, as we're moving through this presentation, post your questions in the chat. Again, I have Mr. and Mr. Rodrigo Paramo, who are present today as well to help moderate. So make sure if you don't want to send your question to everyone in the group, we are now at 52 participants. You can message me privately or Noah Fuentes privately or Rodrigo Paramo privately if you have a question that you would like to ask anonymously. So without further ado, we're at 12:05. Judge Guerrero, Mr. Richard Losa, please get us started. I will start the timer. Thank you.
Thank you, Judge. So Monica and I put together a list of issues and items that we felt were worth repeating. To some of you, this may be redundant, but just to give you some little practice tips, we hope that you'll find at least one or two items informative for you. So we're going to begin with evidence. We're going to begin with photos. And Judge Guerrero?
So it's really important that when you are talking to your applicant, that they understand that when we go to court, it's not just what you say, it's also what we can show. So when we asking for photos to come to court, we also need to let them know you've got to set it up to teach them what you have to say in order to be able to get in a photo. Because there's the legal terms, and again, Richard and I talked about this, and we apologize if some of this seems very primary, that many of you have done this many times, but we're talking just from the perspective for everyone. So to get the photo in, when you ask somebody, is this a fair and accurate representation of what happened that evening? They may not understand completely what you're saying because that's technical legal stuff. So you need to let them know, hey, we can't just take our cell phone and show the judge. You know, we can't just scroll through Facebook and show the judge. We got to print these things out and have them on paper, because as lawyers, we kill tons of trees, and we introduce these documents so that the judge can have them, especially with Zoom now, because we're not there in person to hand them to the judge and then hand them back. So that's our first tip, is make sure that they understand that they are printed out and that you've got to ask them certain questions in order to be able to show the judge.
And you also have to make sure that you place it on a USB drive. We're lucky that we have an IT department, and our IT department said that when judges require us to place it on a Google Drive, that is not secured. And so if you're representing these victims of domestic violence and these judges are asking you to drop everything on a Dropbox, you have to be careful what sensitive information you are placing in those Dropboxes. And so the safest way that we found in order to introduce evidence is to put everything on a USB drive, inform the judge of the sensitive material, ask them to be patient, and then just introduce that one piece of evidence at a time as necessary. Also, we want to make sure that your photos are legible and you can see the injuries. A lot of you know that bruises don't show up till 2 or 3 days later. So you want to make sure that your client takes photos of those bruising days after the date of the incident. And for a choking incident, those bruisings may not even show up till 7 days later. Now, if you're fortunate enough to get photos from the San Antonio Police Department, they have infrared cameras that can show handprints immediately. But not all of us can subpoena those, and Monica and I are going to discuss those. Monica?
So from Mr. Loza's perspective, he works for legal aid. So a lot of times they have mechanisms in place to be able to get certain documents and things. However, in private practice, that is not necessarily the case. And you don't always have police officers that are really ready and willing to come in and help you in these cases. So you do have to issue a subpoena ducis tecum. You need to ask the officers to bring in their police report. You need to ask the officers to bring in the photographs as the applicant, because again, their job is to assist the district attorney's office in prosecution and not necessarily help the private bar in getting the protective order. So you need to make sure that you put in your subpoena the ducis tecum, demanding that they bring any type of records, any type of police reports, any type of photographs, anything that will help you in your application to get the protective order.
And we're going to discuss this further later on in our presentation. We want to move on to medical records. Obviously, you subpoena the custodian of records, but if you're going to subpoena a doctor, be prepared to have a motion to quash filed against you. And usually these motions to quashes are going to come from big law firms. And a lot of times what I do is I negotiate with that lawyer and say, okay, I understand the doctor is not going to come to testify. I can't afford to pay that doctor. But can you give me certain medical records, or this is the information that I am seeking, even to determine if I'm going to use it in court. So a lot of times, we want you to consider perhaps discharge papers that are provided to the victim. The victim can introduce that into evidence and say, this is a copy that I received. My injuries were a concussion, there were a broken jaw, a broken leg, and so you don't need the doctor for that. And then Monica's going to talk about the criminal side on the motion to quash.
Well, in terms of the motion to quash, again, when you're in private practice, the doctors aren't very likely to want to cooperate. They'll get the subpoena and they'll be like, okay, well, my rate is $450 an hour and you'll have to place me on standby for 3 hours. So we need a check for $1,350 so that we can be ready and willing to help you. Well, that's not really very helpful, because a lot of people that come in as an applicant are not in a very good position to have that extra resource to get the doctor. So you may have to have a hearing on the motion to quash. The other thing too is when Richard's talking about motions to quash in terms of the doctors, sometimes we need to look for other avenues that may be a little bit less expensive for our clients to be able to come in and testify. So instead of getting the doctor, maybe we can get a nurse or a nurse practitioner to come in that may be more likely to come in and cooperate with a subpoena at the time.
And with the nurse practitioners, just to give you a quick example, my client took the child for a physical examination of the children. The children were fine. My client then handed over the children for a standard weekend visitation to the other side. The other side brought the children to school, and to daycare, the children came with bruising. Okay, so the other side never reported the bruising to Child Protective Services nor to the police, but alleged that my client was the perpetrator. And so what happened with between those 3 hours that my client took the children to the doctor and that following Monday, so my client only had that short 3-hour window to abuse the children if my client was the abuser. So we brought in the nurse practitioners to come in and say, no, we examined the children, they were fine. When we left them with the perpetrator, brought in the daycare workers to show the bruising came after the other side had the children. So that's where it might be important. I didn't really need medical records. I just needed that eyewitness testimony. Okay, we're going to move on to police reports, and this is now during COVID times. Monica.
So police reports used to be really easy to go and get. You tell the client, hey, you want to go downtown and go ask for the police reports for every incident that's happened at your home. And they also have the ability to run what's called a survey. So the police department can survey how many times the police have been dispatched to your home. However, because of COVID, now you have to make special appointments because it's not just a come on in, we're welcoming you, because there's a lot of protocols that need to be followed. We need to make sure the police are safe. So a lot of times they are requiring an appointment to be made for you, the police reports. As of 2 months ago, we were required to make an appointment to get the reports.
And because the San Antonio Police Department will not send you these police reports electronically. So once you go downtown, you need to make sure you identify yourself as an attorney. And if you don't have an appointment and you're lucky enough that they're going to let you in, they will do temperature checks, but at least you're able to go in, and if someone's available, they will see you, but the appointment's always better. Now, let's say that the incident did not happen within the city limits. Now you're having to deal with the Bexar County Sheriff's Office. Again, you're going to have to email the individual. I'm hoping she's online, is Linda Miranda. And Linda Miranda is great. You want pictures, you want police reports outside the city. This is your go-to person. Otherwise, and I love our Bexar County Sheriff's Office, but like any other agency, you're gonna go through a lot of red tape, okay? And so if you want them quickly, that's the person you go to.
And also remember, when you're conducting your interview with the applicant, you need to get that timeline and the time frame, because you're gonna get all this information to prepare the affidavit already. But you need to listen to where they're living. You know, some people are like, yeah, I called the police. Well, who came? Well, the policeman. Well, which one? I'm not sure. I'm not sure. So then you have to figure out where do you live. So it might be Helotes. It might be Fair Oaks. It might be Alamo Heights. It could be Balcones Heights. So you can't just expect to go to the one-stop shop at SAPD or Bexar County Sheriff's Office and them have everything. So we need the assistance of the applicant to decipher where was it that officers were dispatched. And if they've moved, if an incident happened a month ago or 2 months ago, where were you living then? So that you can figure out where these reports are at. And when Richard talks about red tape, well, that's red tape for an agency. But and oftentimes too, if you're the private practitioner that is trying to get help for your applicant and you go down to try to get this information, they're not going to be very cooperative about releasing all this information that they're using to prepare their criminal case. They don't want to compromise the investigation and give you all of their photographs, etc., so that they can have all that information available for the defendant to be perusing.
And going along with what Monica just said, each municipality is different. So you're gonna have to follow their rules. And sometimes the municipalities, they know your clients. They know your client's history. They know your client's family. They know they tried to help in the past with this domestic violence. And so a lot of times when you call them, they know exactly where that person lives and who you're talking about. And some of them are very cooperative and they will come to testify for you. They will turn over that evidence. But if they don't, then again, it goes back to what Monica says, you're gonna have to subpoena them and hope they show up in court. Now, Monica and I have different experiences with business records and having police reports certified as business records. I have not had a problem with our Bexar County judges allowing them in as evidence. And so, so that's one avenue for that I found very helpful. Monica, you want to talk about your experience?
And it depends. You know, Richard mostly works in Bexar County. There might be some other smaller counties that the judge let those police reports in, or even here in Bexar County, you could get a visit, you could get somebody that isn't familiar with different rules or may interpret the rules as police report and criminal are hearsay and they're not going to be allowed to be admitted. So although we can try to get them certified and introduce as business records, it's going to depend upon which judge you get assigned and what their decision is at the time that we're trying to introduce those records.
So we want to talk about now recordings and cell phones, videos from cell phones, or any type of social media like text, emails. Look at your Facebook replies. Sometimes we get photos when the perpetrator denies owning a gun and the perpetrator is holding a gun in a photo showing up the new weapon, okay? Sometimes you get real lucky that way. Sometimes you get lucky where the perpetrator says, I don't smoke, I don't do drugs, and then in the reply, you see them smoking a joint, or you see them at a party smoking a joint, or doing meth, for God's sake. You know, they put that on social media. We don't have time to go over predicates, but if you want to privately email me for text messages, I have 17 questions that I normally use to lay down the predicate for text messages, 12 questions that I use to lay down the predicate for emails, and Monica's going to talk about predicates on videos.
And again, this is the same thing, kind of like with the photographs. A lot of times we're used to the fair and accurate depiction. Has the document or the videotape been altered in any way? So you have to kind of explain these things, because everybody that is coming to see you, they're in a time of crisis. So they're not really thinking too straight about, what did she just say? I don't understand. So you have to go through all the steps carefully. You know, I'm going to show you this video. I'm going to ask you, have you seen it before? Has it been tampered with in any way? So that they feel more comfortable practicing ahead of time before they go to court, because court is already scary. They're already having to sit there with their perpetrator, and there's a lot of pressure. So make sure, again, that you go through all the predicates for videos, for anything you're trying to introduce, so that they will not get confused when you're sitting there and asking them these questions.
And a lot of our judges in Bexar County, as long as the social media has a date or a cell number or an account address that the victim recognizes, they'll let it in, okay? But you also have to be careful about Instagram, Twitter, and Snapchat. And the caveat to all of this is you also don't want your victim replying back, because the judges are not going to be happy if the perpetrator is threatening you and then you reply back with a threat, or you reply back, oh, I still love you, I want to reconcile, I want you back. So make sure you counsel your client. I tell my clients, no contact with the perpetrator whatsoever, including social media. And I go down the list that we just discussed because many times the clients want to get back at the perpetrator. They want revenge. They want to be able to respond. It's very difficult for someone to be attacked and not be able to respond back. But don't do it, because our judges are not thrilled. They don't, and I don't want to speak for all the judges, but they don't want to, the first thing they say is, how can you be afraid of this perpetrator if you're threatening that perpetrator back, okay? You don't want to go there. And Monica's going to talk about a social media duplicator.
Right, so I did have a case where we had all these beautiful pictures that showed all kinds of violence and all kinds of different things, guns, weed, the whole 9 yards. But it turned out that they used a social media duplicator, which I had no idea about because I don't have a technical support like Mr. Loza. So we found out that, in fact, there are certain websites that you can pay to get an app that will make it seem like you're that person selling yourself on the back pages of that website that's the dark web. So make sure that you are looking at an authentic document when you're talking to your client. How do you know this is their Facebook? Is this actually your Facebook and their Facebook? Is this actually your Snapchat and their Snapchat, et cetera, before you go in and introduce a document that you later on found out that it was computer generated.
Okay, so we're not even a third through our paper yet. So we're gonna, Monica and I are gonna have to skim through some of the more important stuff. So with witnesses, when your witness is testifying, make sure they wait to respond before they reply to your question or the opponent's question, because of Zoom and the delay. My last case, I objected 3 times and my client could not hear me. And she was testifying to evidence that that I did not want her to talk about at that time, okay? So instruct them to please wait until a few seconds to make sure that you're not objecting. Also, don't give details about the domestic violence, but not what happened that entire day. The judges get very frustrated when they start their day and they discuss every single detail and they don't get to the domestic violence until 10 minutes later, 15 or 20 minutes later. Okay, you do want them to give a detailed account, but not everything that happened that day. And then Monica?
And then only answer the question asked. Again, high stress environment. Even with Zoom, you're still feeling stressed because that guy's staring at you and you can see his little icon on the computer and it's just making me angry. And I want to tell you all about his new girlfriend who's sleeping on my mattress and I can't believe this is happening. And then they start going on and on. So make sure that we don't deviate from the actual issues here, which is I was abused, I need help, I need protection. Answer just the question that's asked to you and make sure that they don't go into a long tirade.
And you also want to make sure that you address any issues where the defense attorney is going to say, the victim is filing this protective order to get the upper hand in a custody. The victim is filing this divorce to get an upper hand in the divorce for alimony. Or they're getting an upper hand because the victim wants to get a U visa for immigration purposes, or wants the perpetrator deported. Bring them up front, get rid of them up front, okay? So normally what I do is if there is a SAPSER, an OAG order, or a safety plan, let's address that to the judge up front and say this is not a custody case to get the upper hand. If my client's agreeing to supervised visits or standard visits or leaving those SAPSER orders in place, bring that up, put it into testimony immediately, and let's dispose of that and concentrate on the domestic violence. I consult with immigration attorneys, and if what the defense attorney is telling me is not true, bring that immigration lawyer to the stand and address that your client is using this to get the defendant deported. Or as many of you know, under a U visa, if your client is a victim of domestic violence, they can stay in this country. Address that up front as well, okay? Try to get all these little defense attorneys, little habits where they try to tell you they're only here because of the upper hand. Dispose of them up front. Monica?
And what a
time.
I was at time. What a
Time.
interesting note to transition to our wonderful defense attorneys. Thank you for sharing your knowledge. And Judge Guerrero, Mr. Richard Loza, thank you very much for your presentation and your tips. I'm sure we will get more of them. But we do have a question. I just want to make sure that it's on your notes when we do get to questions. There's a request for Linda Miranda's contact information as well as your email address. So if you could let us know and have those on your notes, that's where we'll start with the questions. Mr. Ernest Acevedo, you are next, sir. I've got 10 minutes timed. You may begin. Thank you.
Thank you, Judge, and good afternoon, everybody. My name is Ernest Acevedo. I practice exclusively criminal defense in San Antonio. And so Judge Alvarez asked me to kind of give my perspective on this when I get a protective order case into my office. My position, I try to help respondents. And so I tried to think of the most practical way I could help people, especially civil lawyers who might not be in the criminal side of the courthouse as much. Just some of the thoughts that I think you need to consider when handling these cases from somebody who's being accused of doing something. So the way I evaluate it, somebody comes into my office and so there's an application for a protective order. So the first thing you look at, all right, is it a private attorney, usually through a divorce or custody or child support issue, or is it from the DA's office? You first identify that, because my first consideration is to figure out what kind of criminal consequences is the person going to be facing. If a protective order is granted, obviously you can get a criminal case if you violate it. There can be a finding of family violence, that can affect your gun rights, but they can't put you in jail for the protective order itself. Obviously, if it's a family violence case and they're alleging assaults, those can be Class A misdemeanors. We have the newer choking statute now. So if it's a first family violence case, but they allege that their breathing was restricted in any way, that becomes a third-degree felony, 2 to 10 years in prison. If it's a second family violence case, again, it's a third-degree felony, 2 to 10 years in prison. And so those stakes are so much higher than just the protective order. When you come at it from the criminal defense perspective, you really need to protect your client from as much potential to the incarceration as possible. So I always evaluate it from that side. If I can use a protective order case to help the criminal side, that's always where I start the line of questioning. Now, if it's in a divorce proceeding and there was no arrest, and from as far as we know, there's nothing that's been sent to the DA's office as far as prosecution. It's just, hey, during the marriage, he assaulted me a couple of times, a year ago, 2 years ago, I've had it, I'm fed up, I'm out of it, but I'm worried for my safety, so I want a protective order. In that case, generally, you do want to make sure that there's no referral at the DA's office. If you call certain prosecutors in the office, it's pretty easy to get an answer if somebody, either by SID number or by date of birth, has a case pending. Now, if they get arrested, it's easy. It's a public record. You can go to our version of CJIS, where the Bexar County clerk system, and if there is a case pending, it comes up with all the relevant information. Now, if it's a case at large, that means they did not get arrested for an assault, but somebody has submitted police reports to the DA's office. That's considered an at-large case, and those cases get evaluated by the intake section of the DA's office, and they decide if they're going to file criminal charges. And that process, I've seen it take a couple of weeks. It usually takes months. Sometimes it takes a year or two before they file a case that comes in at large like that. During COVID, it seems to have slowed down even more. I just got an indictment on a case that happened a year and 9 months ago, and they just got indicted a few days ago. And so first priority is find out if you think there's going to be criminal consequences, because that has to be the number one priority for a person accused when you come into those protective order hearings. Obviously, if it's through the DA's office, then it's a lot more likely that there's going to be a criminal case coming down the pike. And so if they get arrested the day of an incident, that information is very easy to find. If it's a situation where they come to the DA's office and they did make a police report, but the person didn't get arrested, that's where you have to do a little bit more of a thorough search. And sometimes it can take a month before the case even gets to an intake attorney. And so I always like to reset the case at least one time and get a 20-day extension so you can gather information, you can find out if there's going to be criminal consequences, and you can advise your client of such. As far as basic rules, because I know we're going through this quickly, number one, please do not have your client testify about the facts of a criminal case at a hearing unless it is completely thought out and necessary. Because if they testify, they will be put under oath. There will be a testimony that can be transcribed. Those absolutely can be used by the district attorney's office in the prosecution of a person that you're representing. And so it would be a very rare circumstance where I would have a person testify about a matter when they're going to be able to be cross-examined on the accusations from a criminal case. So that's kind of an easy one, but I've seen people just decide to fight a civil case and they're fighting a divorce. And so they put somebody on the stand when there's been a referral for a criminal case, and confessions or statements of even if they're trying to mitigate it can be used against a person. Now, on the other side of that, the way we defend these cases, I can tell you, like, it's most serious when there's a child making an accusation of a sexual touching of some sort. The DA's office will oftentimes prosecute those cases. And that's where, again, you got to make some serious decisions, because any indecency case or sexual assault case comes with lifetime registration, not to mention anywhere from third-degree punishment all the way to 25 to life punishment, depending on what the accusation is. And so obviously those consequences can override the importance of an actual protective order when trying to address the rights of your client. I can tell you, again, I try to reset those. You try to get as much information as you can as to how valid the defense is. We just had one a couple of weeks ago where the affidavit from what was now an adult, but it was an 18-year-old saying that stuff happened between the ages of 6 and 18. But in the affidavit, from the defense perspective, all the stuff she was detailing for the last 6 years was not criminal. Like, he patted my bottom in the laundry room, with clothes on. That wouldn't be a crime criminally. Or that he play wrestled with me, and I could feel him through his clothes, and it made me uncomfortable. Those aren't criminal allegations. The stuff that would be criminal allegations was very general. He touched me with no detail about it. And so when going over a client about facts like that, he gave a lot of defensive issues of saying, well, that's impossible. Like if she's saying I did it on a trip to Mexico, the whole family stayed in one bedroom. And so he had defenses that would be good for cross-examination as far as, there is a potential criminal case coming down the line. This affidavit has issues where from the defense perspective, wow, there seems like there's a lot of problems. There's a lot of stuff that she's saying with detail that isn't a crime. And the stuff that she's saying that would be a crime has no detail whatsoever. And so in that situation, I would generally want to take that witness under cross-examination, because having a transcript where she's going to have a hard time explaining some stuff, being cross-examined by somebody who's experienced and trying to break up the details of that is very valuable towards defending the potential criminal case down the line. And so in the end, and this oftentimes happens, I try to find out where the criminal case is, if it's an intake, if it is going to be charged, or at least it's going to be reviewed. I do try to make sure that we do cross-examine everybody, because it's in the respondent's best interest to at least know exactly what he's facing under oath. And if you have that information, it can be very useful at the trial, especially if the person doesn't testify very well. Now, when the DA gets to know about this stuff, oftentimes they will dismiss a protective order rather than subject a complainant to a prosecution. In which case, yeah, you might win the protective order and you don't get the transcript. I think it's probably more useful to have the transcript, even if it means you're going to lose the protective order hearing. But those are the things to kind of consider when you're dealing with a respondent. Additionally, like I said, if you get a finding of family violence, that's going to stop your client from being able to hunt with a gun, be able to possess firearms. There's federal statutes that once that family violence finding is there, that's enough to do that. That can be done from a protective order. If you have an agreement where you agree to a protective order without the family violence finding, then that doesn't happen. And in the end, you still have to consider the criminal case first. The last thing, I know I'm running out of time, so the last thing that I think is very important, and this is the most complicated issue in dealing with protective orders when there's a potential criminal case. Ethically, we cannot negotiate the protective order and the criminal case together. It kind of creates a problem, and so it's the hardest thing to deal with. And so the way I try to handle it is that I try to negotiate the criminal case on its merits. Some assaults are better than others. Some sex cases are better than others. And if it is a particularly weak allegation, you try to talk to the intake lawyer before you have the protective order hearing to see if there's any way that the case can be rejected or not charged. And in the end, if you can get to that point, a lot of times you can have agreed protective order without a family violence finding. But you can't negotiate the two. You can't tell the ADA, say, hey, look, I'll agree to this protective order, but just kind of get me an agreement not to prosecute him on this crime later on. We can't do that as lawyers ethically. There's rules that prohibit that. So you have to kind of take them on their own. And so from that perspective, for me, it's always best to go talk to a different lawyer who's handling the criminal case, see if there's a way it can be negotiated before filing, or even if he got arrested shortly after filing, see if there's any kind of agreement that you might be able to reach. And if you can, then you can deal with the family violence prosecutors or the protective order prosecutors to try to work out something with them that might be beneficial to your client. But it's very tricky to kind of balance that equation. It helps that there's two different lawyers. So you're dealing with a lawyer for each of them. And that's a good way of keeping the negotiations separate so you don't cross the ethical lines. I think I've gone over 10 minutes already. So
Yes, no, thank you very much. And thank you for that. And I'm sure our questions will start there. So I appreciate you. Mr. Marco Bass, certainly last but not least, I've got, sir, you may begin.
Alrighty, good afternoon, everybody. I agree with Ernest. When you first get someone in your office, usually they come to you in a rut. So it's very important that you explain to them the difference between what our position is going to be and our interest. So they may come to you in your office when you're doing your intake, and they're going to tell you that she's lying, that she's embellishing the story, and that's great. That's his position. But the underlying interest is usually that criminal charge that we know the state is going to bootstrap along with this protective order. So it's very important that you explain to them what our underlying interest is, which is usually a criminal charge, whether the accusation is a sexual abuse, stalking, assault. That's usually the underlying interest. Now, depending on the accusation, once you're in the hearing, the way I go about it is I pull the pattern jury charge depending on what the accusation is, and I look at those elements that the state is going to have to prove up in the later criminal trial, and that's really how I go about cross-examining the alleged victim. I really hit those bullets, those elements that the state would later have to prove. When you have them on the stand, the alleged victim, it's very important, as Ernest said, for us to get that transcript. We really want to commit them to a story, because later on in the criminal trial, it's really hard to tell a lie twice. So we want that transcript is going to be very important. So we really want to hit those elements of the charge. When you first get a client in your office, again, they usually come to you in a rut and in complete disarray. So it's really important that they know that you're going to fight for them. And these type of hybrid cases that are a little bit, civil and criminal in nature, you really have to be aggressive on them, because again, the criminal charges, the criminal accusations later are usually much more, there's more at stake, as Ernest said, actually, than this pending PO, protective order. When you're cross-examining the witness, again, it's a very serious matter, because if you get the protective order, you can void your Sixth Amendment right later to confront that witness in the criminal trial. So you really need to get everything as much as you can in that mini bench trial. If anything, treat it like a deposition. Again, really hit all those elements, all those points for that later, much more important criminal charge. Now, again, when we're deciphering between position and interest, it's not always just a criminal charge that later may get bootstrapped down the line. It's, let's say he's a peace officer or he's in the military, and if he gets a protective order, and he's not going to be allowed to have a gun, he can't work. While there may be an exception, the state laws, there's not a federal exception for peace officers with regard to guns. What else? There's also immigration rights. If your client is not a citizen, and if there's a protective order and they violate, they may be deported. So there are federal consequences. What else? Again, the standard is different in a protective order. It's not in a criminal case, right? It's beyond a reasonable doubt. We know that. It's less. The standard is less in a protective order. When you first get a client, again, in your office, they know that it's not lost upon them that the alleged victim is usually a woman. The judge might be a woman. Jurors are going to be women. The state prosecutor may be a woman. Like, that's the truth, and it's not lost upon them. So again, you really have to be aggressive in these cases and go to bat for your guy when you think that, or usually they're innocent, right, when they come to you. So that's important to be very aggressive in these cases. It's important to be aggressive because a lot of times if you can stay out of a hearing and maybe come to an agreement and preserve a lot of your legal rights with the later criminal charge, if you can come to an agreement, that sometimes might be in your best interest, right? Cost-benefit analysis. A lot of times our jobs as a lawyer is to tell our client that, hey, this might not be in your best interest to do that, because a lot of times they are upset that the alleged victim is lying and they just want to get in there, not understanding the later ramifications that their testimony may hurt them. So a lot of times you have to, that cost-benefit analysis, you really need to explain to your client what's at stake, what's our interest, what's important. So that's really how I go about it. And that's it. Judge, if you want to save some questions save some time for questions. I know I was going last, so I try to keep mine short.
Yes, sir, Mr. Bass, could you share with the group how it is that you prepare your client for a potential cross-examination on the civil side, that there may be a criminal matter either already filed or soon to be filed? How is it that what tips could you offer about how you prepare your client for that examination?
Well, off the bat, we let them know on certain questions that we're going to plead the fifth, as you might imagine. And I really try to keep that door closed. I try not to open the criminal matter, depending on which judge you're in front of. Certain judges might say that are maybe not too familiar. Certain civil judges that might not be too familiar with criminal cases. Some may say, "Hey, you opened that door, Marco, so your client needs to respond," or other judges might say, "No, the door's still closed." It just depends. I really try not to get too much into it. I just have them plead the fifth, Judge, to be honest.
All right. Is there a time or space where you have the boundary, like what it is that they can answer, what it is that they can't answer, or
Yes.
is it a running counsel that you have for the duration of their examination?
So I usually explain to them all the elements of the criminal charge, and we try to just annihilate those elements. So anything that I'm going to let them get in is to disprove those elements. That again is just attacking the elements that the state would later have to prove in the criminal charge.
All right. Thank you, sir. Thank you so much. So that brings us to our question portion, but if I guess we got the applicant, you have a brief reply period if you'd like for 5 minutes. Judge Guerrero, Mr. Loza, if you have can do a quick, I guess we'll do a reply, 5 minutes if you've got the material ready. And
We have the material ready. Of course, we're ready.
I know.
A couple of more tips that we weren't finished with our paper. Monica and I wrote, I get an hour paper for this. But a couple of things. Please don't forget about section 84.006 that talks about a hearsay statement of a child victim of family violence, that you can get that in as long as the child is 12 years or younger. Many of you will recognize that in the SAPSR statute under 104.006. Okay, so don't forget about that. Also, don't forget about 85.021, where you can request a judge for possession and access of a child, support of your victim and the child. You can also have exclusive use of homes, vehicles, firearms, and pets. Don't forget to add that pet into your protective order. Now, Monica and I wanted to briefly talk about preparing your victim when you have no witnesses, no evidence, and it's a she said, he said, okay? Because those are the difficult ones to get protective orders. So if we may, client preparation is key, and please prepare your client to tell his or her own story in their own words, and make sure that your client doesn't sound like your client is seeking revenge in any way. Be very careful of outbursts, standing up and moving around, tone of voice, and reactions. The judges pre-COVID would be able to view your victim and look at your victim and look at the perpetrator together. They can still do that in a gallery. So those are still very important. And so you have to be extremely careful that you have to prepare your victim. One victim took 3 days to prepare in order to eliminate everything we just discussed. Monica has a couple of more issues.
So Judge Alvarez, I'm glad that you gave us the additional 5 minutes, because Richard Loza has at least 55 minutes left to talk in him. When looking at the documentation that he's talking about, the client preparation is the key. And it's the same thing when you're doing the affidavit to get the protective order and make the application for the temporary ex parte. So you need to garner as many facts as you can. And you need to ask them, why didn't you call the police? Why didn't you tell somebody? Why haven't you left? Because those are questions that are going to be asked for them later on. So you've got to flesh out those details on the front side. You may not put all that stuff in the affidavit later, but all of these things will help to refresh the recollection of your victim when they have to testify. Because again, it is very important that they're prepared and that they know that even if we're in these little boxes, like little icon boxes, that they can still see this person that was abusing them. So it is intimidating, but they've got to stick to the story and they've got to tell you everything, the good and the bad, because you need to be prepared. And we've got to prepare them as well for what bad stuff they're going to say about them, especially in a he said, she said type thing where there is no physical evidence to show the judge. Richard, were you going to go in?
All right.
Yeah, well, I will, but I'm looking at Judge Alvarez
Oh, she sent
for
us a text.
permission.
Never mind.
Yes, we've got about a minute and a half on the 5-minute block, but so I guess one more back and forth and then we'll get started with questions. And folks, if you would please send your question in the chat. I do have a couple of questions to get us started, but please populate the chat with your questions, as well as look to the chat for the CLE number. We got that a little bit late, so it's there in the chat and I'll announce it at the end. It's 174098072, and I just used y'all's 30 seconds, so you've got it back. Go ahead, Mr. Losa.
So I'm a little bit different since all I do is protective orders. So I have an immigration lawyer on standby to answer my immigration cases questions when that issue arises in court. I'm able to call that individual as a witness if it's brought up during the hearing, especially if I haven't rested. I also have a domestic violence expert on standby to testify. Our Bexar County judges are very well informed on domestic violence, but anytime you have a new judge and then your opposing counsel is saying, well, why didn't your victim leave after the victim got abused 7 times? Why did the victim reconcile? Why did the victim wait 3 or 4 months, to bring this protective order? You want to be able to have that your client not only testify as to why it took your victim so long to come forward, but also that expert to tell you exactly the cycle of violence. Okay, so get your expert ready. I also have a children's counselor prepared because I immediately, when the protective order victim comes in, I send them to the counselor. And then for especially if the children were victims of domestic violence, saw the violence or heard the violence. Those are my 3 key experts that I have on hand at any given time. And I know that a lot of you in private practice that handle these cases not as often may not have that ability. So give me a call, because there's a lot of people out there that will help you. I see Patricia Castillo is on this gallery. She's an expert. Call her, let her testify for you. She's very well respected with the Bexar County judges. And that's another thing. You want to make sure you bring an expert that's either already been qualified or is well respected, because otherwise it will backfire on you.
All right, any closing thoughts, Judge Guerrero, before we move into the questions?
And he and I have difference of opinion on the domestic violence expert, because the judiciary here in Bexar County is extremely educated and well informed as to the effects of domestic violence on children and families, etc. So I personally don't see the benefit in it. However, because I do criminal cases, a domestic violence expert can go a long way in a criminal prosecution.
All right, thank you very much. So are there any questions? And we have the email address for Mr. Losa in the chat. It is rlosa@trla.org. If you send him an email, he can get you the contact information for Linda Miranda, as well as the predicates that he referenced. Any questions? Let's go ahead and open up the floor. If not, I've got some questions to get us started. All right. I have a question for Mr. Acevedo and Mr. Bass. How is it that you, to the extent that you're dealing with scenarios where the applicant and the respondent share children, how do you address the provisions for access to the children when there's resets? Is that something that you try to negotiate in the context of the reset, or is that something that just gets on hold until the case can be tried or negotiated?
I'll answer that question first. I mean, the resets are 20 days max in San Antonio. I think it's 14 if you're in a smaller county. And so it depends on how serious the accusations are. I mean, if somebody's looking at felony charges and there's a no contact order, I generally advise a client saying, okay, take 20 days off. You know, we have to worry about potential incarceration. That kind of overrides 20 days, in my opinion. That's usually my recommendation. And if somebody wants to have supervised visitation in the meantime, well, then you can make those arrangements. But a cooling off period when everything's hot is usually best for everybody. And so from the criminal side, I try to recommend that anytime I can. And most of the men, and again, it is over 95% men that are on my side, they generally will listen to that advice and deal with the cooling off period. And it seems to help everybody.
Thank you. Mr. Bass?
No, I agree. Just stay away. That's just stay away. I want to have to deal with that. I'm very firm on that because I learned the hard way on that. A lot of times in the beginning when I first started, my clients wouldn't listen. So now I'm very adamant about abiding by the order and whatnot.
Judge, can I interject?
Yes, please.
When Richard and I were talking about long spans of time between the time that a victim comes in to get a protective order and the time that the violence occurred, a lot of times they're under the mistaken impression that the temporary ex parte order or the emergency protective order that is granted a lot of times by the magistrate judges. So it's a magistrate order of emergency protection that they have that only lasts 61 days, but they're under the impression that it lasts longer. So that's another consideration to have in these types of cases, is that if they disappear for a bit, it's because they thought, well, I already had my paper. So that's just why I didn't come right away.
And Mr. Losa, do you have any thoughts on what you do in order to, or what do you do in the situation where the applicant and the respondent shared children and there's been a request for a reset? How do you address the visitation, the possession, access, and support provisions in the protective order statute?
Okay, well, it depends. First of all, victim safety is always number one. It's key. The children's safety is also very key. So what is going to be safe for the client and the children? Sometimes if there's a SAPSR order in place, the client will say the perpetrator is a good parent and we keep the same visitations. But if that's not the case, then it just depends. Were the children victims of the DV? Then yes, no contact until we have a hearing. If the children were not victims of the domestic violence, then is it safe for the client to exchange the children? Sometimes if the client says the perpetrator won't harm my children, let's follow the SAPSR order, well then let's change the exchange place to a supervised location, okay? But 9 times out of 10, I will ask you not to allow the perpetrator to have access to the children for the safety of my client. If I'm going to reset for 20 days, I'm going to continue that argument. I'm going to make a record because a lot of times it's not safe for my clients to exchange those children. So again, it's a case-by-case basis, and it's after I discuss it with my client, and if the Child Protective Services is involved, a children's counselor is involved, then I'm going to bring all of them into the picture, and if need be, I'm going to drag them to that ex parte hearing to extend that TPO, because 9 times out of 10 it's safer just to have no visitations until we have a final hearing.
Thank you. And we have a question. What is it that, or I guess better asked, how do you handle an unreasonable client in this situation? From the applicant side, if you've got a client who's asking for too much, especially in the space where they share, and from the respondent side, when Mr. Bass, to use your terminology, their position is much stronger appreciated than their interest. So we'll start with Judge Guerrero and then move from there. How do you handle an unreasonable client under these circumstances?
Before I went to law school, I was an advocate in the DA's office, and many times we would get people in the DA's office that would be somewhat unreasonable because they were told, hey, you can get this free service, go over here, just talk to them, they're going to solve all your problems right then and there. So luckily for me, I wasn't an attorney at the time, so I pawned it off on the lawyers and let the lawyers handle it and say, hey, tell them that this is not a good case, because all they did is look at them ugly. Now I'm a grown-up and I'm a lawyer, so it's a little bit different. You know, again, it comes down to the facts, and if we cannot get the affidavit with enough facts to be able to even get a temporary ex parte, then I guess now what we do is kind of blame the judiciary that their standards are too high, but not in reality. So we show them the code and tell them this is what we have to do to show it. And unfortunately, we can try to outsource the resources of, why don't you go see the Peace Initiative? Why don't you go see the Battered Women's Shelter? Why don't you seek help here and there? And this is what we do.
All right, thank you. And I'm gonna mix it up a little bit. Mr. Ernest Acevedo, will you please answer the question? And then we'll go to Mr. Loza and Mr. Bass, just because that's how y'all are on my side of things.
Yeah, there's difficult clients. You know, the difficult situations, it's like Eminem says, it's when the tornado meets the volcano. It's usually when the difficult cases are where both sides have issues with their anger control. And so if we've done enough of this work, you've seen the sides where, okay, we have videos and text from both sides where both are violent, both can be mean, both can cause problems, and there's usually a lot of evidence on both sides. Those people that get angry very easily are the ones that we deal with, and that's a difficult situation. You know, client control is important, and I mean, I have dealt with a lot of guys in my office that come in and they want to just tell me about how bad their wife is, and she cheated, and she's hit him with a pan, and she stabbed him once, and they want to ignore, you know, their behavior too. Well, I mean, how did she get all these black eyes? And so, you know, it's difficult. You have to make sure they understand the big picture, and that if they get indicted for a third-degree felony, they're looking at 2 to 10 years in prison, and they have to listen to their lawyer. And then from the defense side, I mean, I have tried to help a lot of these guys find the right counseling, have them find methods where they can stop becoming repeat clients over and over and over again. And, you know, like always, there's success stories and there's failure stories. But usually the threat of prison will keep them a little more rational eventually. But I also believe in the cooling off period. And, you know, and one point that kind of relates to the last one that I think is important, as a practical matter. I mean, as in presiding, you see that the DA's office will eventually dismiss, I mean, probably close to half of their protective orders by the time, you know, before they get heard, even after a few resets. And so one of the things I've noticed over time is that during this cooling off period, if it's a family with kids that had some, you know, a rough month, a lot of times they will make their own arrangements to get back together, and they'll want the system out of their life. Because once the system is in their life and they have this protective order that's in effect for 2 years, it's very difficult to reverse it. And so if you do get a reset for 1 or 2 or 3 settings, a lot of times they'll work it out on their own. If dad's gone and the kids miss him and he gets some counseling and maybe she gets some counseling, a lot of times just resetting the case will resolve it, because they do non-suit a lot of the protective orders from the DA's office just because of time and the fact that people want to reconcile. And so as a lawyer, I think it's very important to at least encourage your client to do what they need to do to try to make this relationship less volatile. And if it's not one that there can be reconciliation, well, then you handle it the way everybody's been talking about. But I think we can't forget that in the big picture, that a lot of these result in non-suits because people want to get back together.
Thank you. Mr.
Judge,
Loza? Oh, I'm sorry.
just real quick, having been in the position in the DA's office, I don't see any prosecutors from that section here, but there are times where the case does need to be dismissed because we have to look at the big picture. And the big picture is, do you want to risk losing a criminal prosecution where somebody can get a significant amount of time in prison if you make a misstep in the civil case, as opposed to going and getting this piece of paper that is going to protect you for a year, 2 years, and then their criminal prosecution is messed up and the case has to be dismissed on the criminal side.
And going along with that, Judge Alvarez, Monica and I, we had to skip some of our presentation, but always check with the district attorney's office, always check with the detective that's investigating that criminal case first before you file your protective order, so that you don't interfere with that prosecution or with that investigation, especially in a sexual assault protective order. Because if you ruin that sexual assault criminal case, then you're risking that someone may be sent to prison for 20 years versus your lifetime protective order. And so you have to be really, really careful. And a lot of times the detective will say, my investigation is over. I no longer fear that he's going to run. I no longer fear that he or she is going to destroy evidence. You may now go forward. Then you have to be able to evaluate that at that time. And the same with the DA's office is exactly what Monica said. But to answer your question about an unreasonable client, I'm in a different situation. If I have a client that comes in as being unreasonable, the first thing I'm going to do is have my victim talk to a domestic violence counselor, a counselor that's specifically only for domestic violence. We also have social workers that are excellent. Tammy Maldonado accompanies me not only to court, but will speak to the victim even before we go to trial. And then once those two have spoken to my victim, then I sit down with the victim again and say, what are your goals? Our goals are your safety, a protective order, and getting some kind of supervised visits for the children. You're not going to meet your goals if you're unreasonable with XYZ, okay? And a lot of times you are right. We go into court with unreasonable clients. So Tammy sits with my victim in trial pre-COVID in order to try to eliminate some of that unreasonableness. Now, during COVID, it's a little bit more difficult. And like I said before, practice with your client on Zoom and be able to tell your victim, don't do this or do this. Be careful of your actions. Be careful of your answers. You have to prepare that unreasonable client more than once if you expect to get that protective order granted. Because and just real quick, because I have seen victims and perpetrators fight in Zoom and a judge can't control it because you don't have your bailiff there and they're not listening to you, the judge, or they can't hear you. All they can hear is they're yelling. So prep.
And we have this wonderful mute function that I personally love to use. So Mr. Marco Bass, before we go on to the next question, how is it, or what tips do you have? How do you rein in unreasonable clients, sir, in this context, in the protective order litigation?
Yes, Judge, I do a lot of that at the forefront. Really, from the moment they walk in, I'm really driving in that, hey, everything you're telling me, that's great and all, but that's your position. Now, our interest is, again, and that's when I dive into what's important and what's at stake. And again, a lot of times, they just want someone that's going to fight for them and really represent them. And once they see that you're that guy, that really solves a lot of the problem. If they know that, you're going up to bat for them and you're doing your best and I'm protecting their interest, that I try to get a lot of that done at the forefront. So I'm not having to deal with that throughout the entire representation of that client, because that can really cause problems and you can lose a lot of focus if you're having to deal with clients that are like that.
All right, thank you, sir. The next question is, what is the current standard of corporal punishment that is deemed reasonable or acceptable in the law? And I'm assuming that's within the context of protective order litigation. What if, the question moves on, what if both parents are perpetrators and it's a relative, neighbor, employee, or other person making the complaint who I'm assuming who moves for the protective order? And Mr. De Los Santos, if you want to elaborate on the question, sir, please unmute yourself. But I'm assuming, yes, what would be the position of CPS removing for the protective order? Is that what you're asking?
I take it that CPS is the one that usually moves for protective order in that situation. But what if a friend, a relative, a neighbor, or somebody And I'm kind of getting at the issue of sometimes we have nosy people that are neighbors, and sometimes they don't call the police, they don't go to the DA's office, but they do that when they get in a situation where they don't. I'm just, I've heard this from clients that come to me and complain that their neighbors are too nosy. So I'm just trying to figure out, is there any way if they could get through to CPS other than having to call the police? That's really kind of where I'm coming from, trying to figure out what do they have to show in those elements, in those situations where they claim that the parents are being abusive of the child.
Judge, I could take a shot at that one. I don't think I recall ever seeing like the DA's office filing for protective order for a child because of a spanking. But, for all the civil lawyers out there, the law on the issue is very bad for a defendant. I mean, basically, if you spank a child, the law says basically if you cause bodily injury to a child, that's a felony. So that would include a spanking because bodily injury only requires pain legally under the legal definition. And so I have seen some very weak spanking cases indicted, and a person with no criminal history, gets charged with a serious felony. And so the law is very difficult on the issue. Now, the way it happens in practicality is like if a police officer comes or a neighbor calls and says, hey, I saw the neighbor spanking his child, I want to report it. What I've learned is that the position on spanking in the community is so very different. Some people think, yeah, if you spank your child, you should go to prison. Some people say, hey, the only way you're going to teach your child, lessons in life is to be very disciplined with him and spank him often. And so you have to be very careful on the criminal side because depending on who comes and sees you, some officers, again, if it's an officer who has a belief that all spanking is wrong, you're going to get arrested. If it's an officer who spanks his own child, you probably aren't. Now, if there's a beating, if there's bruises, if there's blood, you're obviously going to get charged if a police officer sees that. But just a report of a spanking with the hand can be enough to get you charged with a felony, although it doesn't seem to show up in protective orders very often. If it does, I think it's more on the rare side. But it's just something to be careful about. The crime is very simple to meet the elements on if a prosecutor or a police officer wants to move it forward.
Your Honor, wouldn't you just have them suggest that they make an anonymous report to CPS?
Well, yes. I mean, if the question is, what is it that you do to get help for a situation that you see, neighbor to neighbor, the 1-800 for CPS reports is always open. But to the extent that the question was, what is the law, the penal code, Mr. Acevedo, thank you for enlightening all of us. I didn't realize it was so harsh. But that was it. So thank you. So yes, definitely make a report if what you're seeing is tantamount to child abuse and neglect. CPS never stopped. Neither did the courts. So we just adapted to our COVID situation. We have a final question. Well, maybe not final. If we can, if anyone else has another question, please send it in. But what is the standard of proof in a protective order case?
Richard.
Mr. Losa,
Okay.
get us started.
So the standard of proof for an ex parte temporary protective order is clear and present danger of family violence. And you can find that under section 83.001, okay? Now, for a final protective order, the code doesn't say. And so it's not necessarily the preponderance of the evidence. So many a times these defense attorneys are gonna come after me and say, it's clear and convincing evidence. No, that's not even the standard for an ex parte. It's clear and present for an ex parte. And then they're gonna come back to me and use all these criminal verbiage, the preponderance of the evidence. No, that's not it either, okay? Again, the code is silent. And so if you'll I wrote a paper on this. And so if you'll give me like 1 minute, I will give you some authority that basically the judge, it's a reasonable standard. Basically, it's just a reasonable standard that says the judge has to find that family violence has occurred and is likely to occur in the future. There's case law that says that if domestic violence occurred in the past, that the judge can then infer that it's likely to occur in the future. But the specific, let me look for the authority real quick, okay? So I knew this was going to come up, so
Well, as you're looking for that, because we're at 1:13, I want to make sure that we get in this question about service. And the question is, can you send the protective order to the respondent's attorney if they are represented and appeared at a temporary protective order on behalf of the respondent?
the answer is no. The law requires personal service. Okay, so going back to your standard of proof, there is case law, and that says that that it's not necessarily the preponderance of the evidence. Just it's a remedial. It's just more of a, did the judge find family violence occurred, and is it likely to occur in the future? And the case law, for those that want it, you can find it under 425 Southwest 3rd, 425 and 430. I've got another, the case is Boyd versus Palmore, Palmore. I have additional cases on that, but again, it's not on the code. The short answer.
Thank you.
Uh-huh.
And with that, thank you all so much. I do want to recognize Judge Ellison and Judge DeLeon. Thank you so much for being present. And thank you for present. And Judge Guerrero, Mr. Richard Losa, Mr. Ernest Acevedo III, and Mr. Marco Bass. We are so grateful for your presentations and for sharing your knowledge. Thank you all so much. And thank you all so much for being present and attending and helping build the domestic violence awareness in our community all year long. Thank you. And we are at 1:15 and our presentation is over. Great day and a great weekend. Thank you.